Good evening, everyone. I'm Ellen Yarashevsky from the Freedman Institute at Hofstra Law School, and I'm delighted to welcome all of you. It's so nice to see so many colleagues from around the country, my colleagues at Hofstra, some of our students as well. Welcome to tonight's discussion about the role of the lawyer disciplinary process for some of the most high-profile lawyers in the past year. This includes Rudy Giuliani, Sidney Powell, Lynn Wood for conduct in litigation and outside of it, and for Senators Ted Cruz and Josh Hawley for their conduct and their comments that led to both disciplinary complaints and call for a Senate and Ethics Committee to investigate them. To say this is topical in the news regularly would be quite an understatement. In the past week, there have been 2 disciplinary complaints that were filed in New York against Rudy Giuliani. One signed by leaders of bar associations and academics, and another by the Lawyers Defending American Democracy, LDAD, that was signed by scores of lawyers around the country. As you know, these received a good deal of press. Many of us in the world of ethics have been asked for months now, why aren't there complaints filed against these people? Why doesn't this bar do anything about disciplining these lawyers? And tonight we're going to explore that topic. We're going to ask, is the disciplinary system the appropriate and necessary body to regulate lawyers who violate ethics rules? Is it capable of doing so? Are there alternatives for lawyer regulation? We'll look at lawyer conduct in litigation and lawyer conduct outside of litigation. We'll look at the First Amendment and the extent to which we can or should regulate lawyers' speech. We'll ask about public figures and the extent to which our regulatory systems should be and our effective curbs on conduct in the public square. To explore these topics, I'm pleased that we have 4 of the most thoughtful lawyers and academics joining us this evening. I'll introduce them briefly, and I encourage you to read their full bios. So in alphabetical order, we're thrilled to welcome Dennis Aftergut joining us from San Francisco. He is a litigator and he's founder of the Rennie Public Law Group. A former federal prosecutor and chief assistant city attorney in San Francisco, he currently focuses on affirmative litigation and defending cases involving civil rights and democratic norms that are under attack. Particularly for our purposes this evening, Dennis is on the steering committee of the Lawyers Defending American Democracy, the group that filed the complaint against Giuliani this week. He was one of 3 authors of that complaint. He was also the primary author of a 37-page letter brief this summer against William Barr to the Disciplinary Committee. He's written many op-eds about the conduct of William Barr, Donald Trump, and others in the last year. So welcome, Dennis. We're delighted that Ellen Brotman, founder of Brotman Law in Philadelphia, is joining us as well. Her practice focuses on professional responsibility and ethics, investigations, white-collar criminal defense, and appellate advocacy. She's represented lawyers before the Disciplinary Board of Pennsylvania for more than 20 years and has defended a wide variety of criminal cases, including political and public corruption, corporate securities fraud, and other white-collar crimes involving complex trial, sentencing, and appellate issues. She's a frequent writer and speaker about criminal defense and professional responsibility-related matters. Welcome, Ellen. And then we have 2 of the most well-known and highly regarded legal ethics professors, both of whom are my colleagues in New York. Professor Bruce Green is the Lewis Stein Chair at Fordham Law School, where he directs the Lewis Stein Center for Law and Ethics. He teaches and he writes primarily in the area of legal ethics and criminal law, and he's involved in many Bar Association activities. Currently, he chairs the ABA Criminal Justice Standards Committee, and students, particularly, he chairs the Multi-State Professional Responsibility Exam Drafting Committee, and no, he will not answer questions about the MPRE this evening, or ever, probably. Professor Roiphe. Professor Roiphe is the trustee professor of law at New York Law School, where she teaches professional responsibility, criminal procedure, ethics in criminal practice, and American legal history. She runs the Institute for Professional Ethics, and she's the co-director of their Criminal Justice Institute. In addition to a JD, Professor Roiphe has a PhD in American history. She writes on the history of the legal profession and prosecution ethics. You may have seen her opinion pieces on prosecution, legal ethics, and politics in places like Slate and the New York Review of Books Daily, among other popular press. and she's a legal news analyst for CBS News and has served as an expert on MSNBC and CNN. So we are totally delighted to welcome all of them. I will tell you what we're going to do this evening. We're going to try to have as much of a conversation as possible. I will be monitoring the chat, so please put any comments or questions in the chat, and I may intersperse our discussion with those. We are recording this and we will post it. I know that there are many people who have asked us about that. It will be posted on YouTube as well as the Freedman Institute website. All right, so let's start. Dennis, we're going to start with you, okay? So can you provide us a little context about the filing of the complaints? And briefly, if you can, give us some overview of the facts in these various complaints.
Great. Thank you, Ellen. Thanks for inviting me onto a panel of people whose work I so admired. I'm really quite humbled to look at the people who are watching. There are quite a lot of luminaries, and it's a little daunting. I'm here, as Ellen said, because back in July, along with lawyers from Lawyers Defending American Democracy, I was a leader in filing a 37-page bar complaint against the Attorney General of the United States then, William Pelham Barr. We had some guidance from some of the people on this panel, for which is what made it as good as it was. We gathered some attention, Ellen mentioned this, because we had 4 former DC Bar presidents as signers and 23 distinguished DC Bar members. We got stories in Politico, and we got stories in Breitbart that were fair and balanced. And I want to say that I've been lucky enough in my career to do some things I'm very proud of. I prosecuted some bad people, and I led a civil rights case in San Francisco, and I even got to argue in the Supreme Court. But getting a fair and balanced coverage in Breitbart, that ranks pretty high up there for me. And the thing about that complaint, and then I'm going to move on to what we're really talking about, is that that complaint, which I believe is still pending, these proceedings are confidential when the grievance committees review them. But William Barr, in all likelihood, had to respond to that, and that told him that there were people in the legal profession that were holding him to account. And I have little doubt that that, along with many other people, helped control the bad things that happened afterwards. This is a self-regulating profession, and holding violators of the rules of professional responsibility to account is a very, very important function. So let me get to my roadmap. Is, as Ellen said, I want to give a little context. I want to just run through the basic categories of rules, and then I want to just go through quickly the 10 or so complaints that have been filed, not in detail, just to kind of list them, and we may get into the details later on. It's important to recognize that we are not dealing with the ordinary fare for grievance committees here. We're not dealing with lawyers who have missed deadlines consistently. We're not dealing with lawyers who stole money from their client's trust fund. We're dealing with lawyers misbehaving in the public square. Lawyers over the last 3 months, in connection with the Trump campaign litigation that was essentially full of complaints that were unfounded in law and fact, and that were aimed at fueling a narrative, a political narrative, that the election was stolen. And when you are dealing with lawyers in the public square, it's different, and a lot of care needs to be taken. It's the job of accountability to rebuild and restore norms when you have an occupant of the White House whose brand is destroying norms and rules, it's not surprising that that behavior reverberates through all of society's institutions, the legal profession being one of them. And because, as I say, we're a self-regulating profession, it is our job as lawyers to uphold those standards and to hold people to account when the rules get violated, but to do it in a way that does not risk bending the rules in the other direction. In the public square, there is the potential for abuse. We have a sordid history in this country from the McCarthy era of lawyers representing suspected communists who were disciplined. And we do not want to weaponize disciplinary complaints in a way that courts that kind of abuse. So I want to just commend to you three principles that I've sort of learned along the way here. The first one is that it's really good to start recognizing the positive principles that we uphold and what we're not involved in filing a complaint. The Giuliani complaint that three lawyers from LDAD, small correction, Ellen, I wasn't one of the three primary authors. The three primary authors were a former Southern District of New York AUSA named Christina Chung, who was a force of nature, a former Robson Gray managing partner named John Montgomery, and a senior partner at a law firm that I spent some time at a long time ago, Farella Braun Mattel in San Francisco. Just one moment of public service announcement. Farella Braun Martel provided us in this complaint, and this was an 18-page complaint with a 28-page factual appendix that any grievance committee looking at this is going to take very, very seriously, I'm sure. Farella Braun Martel, pro bono, provided us with that assistance. There's been a shortage in some of the rule of law matters over the last 4 years of law firms standing up. So I just want to commend a firm that has. End of public service announcement. So first, recognize the positive rules. What that complaint did was it started off saying, this is not about politics, this is about law. This is not about partisanship, this is about law. We admire and uphold the duty of lawyers to represent their clients zealously within the bounds of the rules of professional responsibility. The second principle is, for me, is that you write one of these complaints in the public square like a legal brief. You state the facts, you state the law, you apply the facts to the law, you ground your complaint carefully in the rules and the court decisions around them. That kind of care can help prevent abuse. And that's what we did with Barr, and that's what this last Giuliani complaint last week, and that's what the complaint against Giuliani that was filed by Ellen and 30 or 40 other New York bar luminaries, including five former presidents of the New York bar. That says these prominent people uphold the standard that this complaint sets. And I think that's very, very important. And the third thing is you keep your powder dry for really egregious conduct. Well, the good news and the bad news is that in the last 3 months, we've had a lot of really egregious conduct. And I want to go through it quickly. Before I do, just, and please, Bruce and Becky and Ellen, jump in. I'm going to just do a sort of quick and dirty of the rules. I see 5 kinds of rules that are being used. The first is you can't file a frivolous complaint. That's rule 3.1 in most jurisdictions. And then the second category, you can't be a liar. You can't make false statements to a tribunal or false legal claims. You can't make them to third parties, and you cannot engage in conduct that is dishonest, deceitful, or full of misrepresentation. So first category, frivolous. Second category, false statements. Third category, you are required, you can't file claims whose substantial purpose is to harm third parties. You can't take action to harm third parties. The brilliant lawyers who filed our Giuliani case used that rule. They said that by the time Giuliani filed, at least 30 courts had rejected the allegations of fraud going around the country from the Trump campaign. Reputable lawyers had pulled back and were not doing it anymore. And so and the claims are frivolous. The only reason for doing it was to harm third parties, to disenfranchise majority voters in many of the battleground states. Fourth, there is what's called the catch-all, and the catch-all is that you are not allowed to engage in conduct that reflects adversely on your fitness to practice as a lawyer. Rudy Giuliani did exactly that. And last, there's the oath that you take, every lawyer takes to uphold or support the Constitution. And in some jurisdictions, DC was one of them, that a violation of your oath is a violation of the rules of professional responsibility. We use that rule when William Barr oversaw the violent military and police attack on peaceful protesters exercising their constitutional First Amendment rights so that the president of the United States could walk, I get a chill even saying, thinking about this, so he could walk across Lafayette Square and take a photo holding a Bible in front of St. John's Episcopal Church. That's a violation of your oath. And that category comes to play with some of these lawyers. All right, I'm overstaying my welcome. I'll try to go through the 10 or so complaints. The first in November of last year, first out of the box was William Pascrell, congressman from New Jersey. You can imagine that Congressman Pascrell's complaint might not have satisfied my second caution. It wasn't necessarily detailed, grounded in the rule with a lot of legal analysis. I don't know him, but I do know I've been around politicians. Making the first splash, being first to market can be very important. Then in December, two former bar presidents in the state of Arizona and some other prominent lawyers filed a complaint against 18 lawyers. By the way, Pascrell's was filed against 22 lawyers who had filed the early Trump suits in 5 different states.
And then, Dennis, were those all on grounds of frivolous conduct?
I can't tell you, I haven't looked at every one of them, but I'm sure that and probably Rule 8.4C, the one that prohibits lawyers from engaging in dishonesty and deceitful conduct and making misrepresentations. Because we know that the Attorney General of the United States, William Barr, said he didn't see any evidence of any widespread fraud that would affect the election. We know that the Department of Homeland Security said this was the most secure election in American history. And then you have these lawyers coming out and making these wild claims. So that was Arizona. And then we have what I call the Texas Three. The Texas Three are, and by the way, the Arizona complaint included lawyers who, lawyer Sidney Powell and Lynn Wood, who you mentioned, Ellen. And there was an individual complaint filed in Texas where Sidney Powell is barred because of her complaint in Michigan that I think Ellen Brotman may be talking a little bit about. So she's the Texas 1. Texas 2 is Attorney General Ken Paxton. He led and roped in 18 attorney generals, Republican state attorney generals, to file one of the most frivolous original jurisdiction petitions ever filed in the Supreme Court, I'm sure. It said that the state of Texas, or whatever state it was, who these other 17 were representing, can sue because the election processes and results in another state are unconstitutional. The Supreme Court dismissed that in about 6 days. They didn't have standing. A first-year law student would have known that. And you can only imagine if that rule were honored. You know, the Constitution, they say, is not a suicide pact. It's not a free-for-all in elections. Hey, I lost the election. I think I'll sue the state where, you know, it went the other way. You know, it's not the Worldwide Wrestling Association. And so promptly the Supreme Court, even this Supreme Court, dismissed it. There have been complaints against Paxton and also the Attorney General of South Carolina, who joined it, and the Attorney General of North Dakota, who joined it. Separate, those are separate disciplinary complaints against them. And then the third is Louis Gohmert, the Republican congressman from Texas. He hit into his own triple play. He filed an amicus brief in support of Paxton's frivolous case. I mean, he was a signer with a lot of other Republican congressmen. He also filed his own case in Eastern District of Texas, where the Trump judge promptly dismissed it. And his claim was that that Pence had the power under the 12th Amendment to select alternative slates of electors than those that were lawfully certified. And it was a complete misrepresentation of what the 12th Amendment says. So he was dismissed by a Trump-appointed lawyer very swiftly. And then he also, after the insurrection, that all these actions were leading up to providing some camouflage for, Gohmert stood up and filed an objection to Arizona's vote. And that one would think might be, and by the way, Gohmert, and just like Hawley is a lawyer, just like Cruz, they're lawyers. So complaints have been filed against Gohmert. Then there's the Giuliani.
I want to go quickly if we can, because
I'm almost done. I apologize. I'm almost done. So then there's Giuliani, who's been mentioned. And then there have been 2 Missouri complaints against Josh Hawley. There are a couple of peripheral things. That is that Lynn Wood and Sidney Powell are the subjects of sanctions. Lynn Wood has lost his privilege to practice in Delaware because of what the judge called a toxic stew of mendacity, prevarication, and surprising incompetence. I think I'll just end there. Thank you.
You've raised a lot of issues. A lot of people on the Zoom don't necessarily know the facts of each of these cases. And I'm just going to, well, nor do we expect them to, right? And we couldn't take a few hours to go through all the facts. But for purposes of this discussion, let's just assume that the categories of violation that you set forth, there are allegations of them, right? That are clear violations, okay? Bruce, I'm going to turn to you and ask you about this. By the way, there's a lot in the chat about what do judges do? Do judges sanction people? How does the disciplinary system work? We're going to try to deal with all of that in the next hour and a half. But Bruce, tell us about this poor disciplinary system we have state by state. What are the goals of the disciplinary system?
So the starting point is we have, 50 states, the District of Columbia, Puerto Rico, Guam, Virgin Islands, etc. And as everybody on the call probably knows, every state has their own process for admitting lawyers, licensing lawyers, and disciplining lawyers. And so Ellen Brotman is a lawyer who defends lawyers in the disciplinary process and probably has a lot more experience. I'm qualified to talk about, if anything, maybe the New York disciplinary process. But I think the starting point that's important is to know that every one of these processes is different. New York has a lot of lawyers. We have different grievance committees that independently investigate in different geographical areas. Most states have a single disciplinary process. Some rely on professionals, lawyers to be essentially quasi-prosecutors. Some rely more on volunteer lawyers or bar associations. If you're in Wyoming, I think there's one lawyer, he's a terrific lawyer, who does everything. And it's a very small bar. So I don't want to suggest that what I'm talking about is representative. It's not. But I'll tell you a little bit about maybe the history of discipline in New York and the purposes of discipline, I think, in New York and nationally are pretty much the same. And something about, I think, the interrelationship between the process and court sanctioning. Because, one of the things we're talking about that Dennis raises is bad conduct in court. It's not all in court, but a lot of it is allegedly filing frivolous lawsuits. And some of the chat questions are, has any court sanctioned the lawyers? And I think the answer is so far no, although as Dennis talked about, Lynn Wood was denied pro hoc vice status. That wasn't in one of the cases where he filed allegedly a frivolous claim. There is a pending Rule 11 motion that I think Ellen's going to talk about in Michigan, brought by the city of Detroit, which was an intervener there. But one could ask, who ought to police this, if anyone? Should it be the courts who oversee the lawyers where the complaints are filed, or should it be the disciplinary authorities of the states in which the lawyer are licensed? And so, or both. And so Dennis talked about a complaint filed against Rudy Giuliani in New York, where he's licensed, growing out of a case in Pennsylvania, where I assume he was admitted pro hoc vice. So, let me go back a step. So a very brief history. This is the second CLE program I've done in 2 days, and I started both in the 19th century, but I promise Ellen to—
No, you're not doing that here.
No. Back in the day, lawyers were informally socialized, and I think that day continued for quite a while into the 20th century. And so to some degree, what Dennis is talking about is a form of professional socialization where other lawyers in the bar are making it known that we don't think very well of this conduct. And to some degree, whether or not discipline grows out of the complaints that Dennis talks about, it's a form of professional socialization. In fact, part of his point was the bar complaint led others to act more cautiously. But beginning in the late 19th century, I would say up until then, courts really disciplined lawyers in an ad hoc way. In the early 20th century, the Bar Association said to the courts, let us take some of the burden off you. And so, for example, in New York City, the city bar undertook the process of investigating and making findings in disciplinary cases and then sending that to our appellate court for them to decide what to do with it. By the 60s or 70s, it was perceived in most jurisdictions, or certainly in big ones like New York, that it shouldn't be done by the voluntary bars. It ought to be done by professionals, the way professional lawyers do criminal cases. And so it became a function of a staff lawyers who were, become familiar with the disciplinary rules and the disciplinary process. And that's how it is in New York. Now, what are the purposes of discipline, you asked? Well, it's interesting because the courts have issued opinions saying the purpose is not punishment, it's to protect the public, which sort of implies that it's not to look back at bad conduct and sanction lawyers. It's to identify lawyers who are a danger to the public going forward and remove them from the bar or deal with them in some other way. But the truth of the matter is courts kind of are doing both. And the punishment is a little bit like the punishment in criminal cases. Obviously, we're not putting people in jail. It's not about just incapacitating people. But, it expresses the importance of the rules. It deters lawyers from misconduct by pointing out that they can lose their licenses. And to some degree, it protects the public as well. And one of the things I wanted to point out is, like criminal prosecutors, the disciplinary authorities have discretion, and the rules of professional conduct expect them to exercise discretion. And so the ABA model rules, which are the model on which every state bases their rules, has a preamble, and it says, the rules presuppose that whether or not discipline should be imposed for a violation and the severity of the sanction depend on all the circumstances, including willfulness, etc. So there's a lot of bad stuff. Well, whether you think it's that bad or not, I guess you could debate, but things that violate rules of professional conduct that occurs in court proceedings that disciplinary authorities are certainly not seeking public discipline for, not seeking suspensions or even public reprimands. And if it's punished at all, it's punished privately, but probably most of it isn't punished at all. So for example, Ellen Yarashevsky and I write primarily about criminal cases, and Rebecca also. And think of the number of cases, civil and criminal, where lawyers violate the 3.4 provision that says you're not supposed to interject irrelevant things, or you're not supposed to make closing arguments that play on jury sympathy. And how is that dealt with? Mostly it's let slide. Sometimes the lawyer on the other side makes an objection and the judge says sustained, and maybe there's a curative instruction. But do you think that disciplinary authorities around the country are scouring court transcripts to find lawyers who interject irrelevant things into court? Dennis probably tried a lot more cases than the rest of us. I wonder how many lawyers he interacted with, including possibly himself, would have been disciplined if anyone took that rule seriously. And likewise, and this gets closer to our topic, there are treatises on Rule 11. Rule 11 is the civil procedure rule. That's a counterpart to Rule of Professional Conduct 3.1 that says you can't file frivolous claims. And I would guess in the 60 some odd cases that were filed, I don't know if all of them, but a good chunk of them were candidates for Rule 11 motions, and only one person filed, one defendant filed. It wasn't even a defendant who was a defendant who was brought into the case by the plaintiff. They kind of came in on their own. And so I would say in most cases, and by the way, 3.1 is not just about frivolous claims or frivolous answers. It's about any frivolous argument that you make in a civil lawsuit or criminal case. And so I would say the overwhelming majority of frivolous things let slide. And to the extent that there are actual Rule 11 sanctions, and there are books filled with cases with Rule 11 sanctions, very, very few disciplinary authorities are invoking Rule 3.1 in order to go after those lawyers. So I think the key point, and one other key point I want to make, but one key point is that there's a lot of discretion. And the other key point is that a lot of this is not public. It's very opaque, and some of it never becomes public. So the states vary. In New York, which is among the most secretive states, nothing is public unless and until there's a formal discipline decision, a public reprimand, etc. Yeah.
Chris, I have a question.
Sure.
Isn't there another reason why the enforcement is not strict? And that's because there needs to be breathing room. And that goes to my point about you keep your powder dry in disciplinary claims, except for the most egregious conduct. Absolutely.
So, in criminal cases, prosecutors exercise discretion widely based on all kinds of considerations. And I think in disciplinary cases as well. Is this a significant case? Is this person dangerous? Do we need to provide breathing room so that we don't chill legitimate advocacy or otherwise legitimate conduct? And the problem, of course, is it's so opaque. In other states, and this is the ABA recommendation, things don't become open up until a formal disciplinary charge is filed, and then the process opens up. But if you're exercising discretion not to file a charge, whether because you want to give breathing room, because this person isn't such a dangerous person, because we'd rather that the courts dealt with this because it's much more efficient if a judge who actually had the case deals with this under Rule 11, and if the court doesn't care, why should we? So many reasons, but we never know. And so look at the frustration that people have in asking, are the disciplinary authorities looking at this? We don't know. Are they taking it seriously? We don't know. If nothing ever checks out, if it's like the Roach Motel, your dentist's complaint checks in, but it doesn't check out, do we know why? We don't know. Not in New York, you won't. And so I'm going to stop there, but I think the combination of discretion and opacity creates a lot of frustration. We're supposed to be a self-regulating profession. We're supposed to give confidence to the public that we're doing our job. But I think the process doesn't do that. And here we have a case study.
And so, Bruce, you're making the case for the fact the disciplinary system doesn't work very well at all. So why use it and why discipline anybody? I mean, you and I, we've written about how prosecutors should be disciplined for hiding evidence and not turning over cases. And we've written that over time. So why isn't this the appropriate case? If we're saying judicial sanctions have a different role than the disciplinary system, and if we're serious about being a self-regulating profession, why shouldn't this be the case where the disciplinary committee gets involved? I'm not just looking at you. Becky, what do you think?
So I agree with Bruce. I think that there's a real danger here. And I want to go back to something that Dennis mentioned in the beginning, which is about concerns about the power that we're giving a particular organization that has so much discretion and that has governmental power. And to me, you have to be the most vigilant when you are the most opposed to a particular view and you want to see blood. And I think right now, there are so many people who want to see lawyers pay for what happened in this country. And I am completely sympathetic with that. I understand that this is a horrible thing that happened and there were horrible people involved, but I just think you really want to be cautious because you set a precedent in doing that. And I know we're going to talk about that a little bit later, but I personally, I think these are great complaints. They're drafted extremely well. Some of them, particularly Dennis's, and I'm not in any way suggesting that there's anything wrong with filing the complaint. But if I were the disciplinary committee, I would be very cautious about acting on it, in part for the reasons that Bruce laid out, which is, look, we don't treat similar lawyers who are situated in similar positions this way. So if we're going to do it now, how is it not a political statement? That's one thing. And second thing I want to say is, about these lawsuits, you know what? They are the best thing that happened to democracy. That the fact that they could find a lawyer, they had to scrape the bottom of the barrel. They lost all their reputable lawyers, as Dennis said, and they were left with Lynn Wood, Sidney, Powell, and Giuliani, who had already blown their reputation by this point. Actually said something. It sent a message, and they went into court and they came out with these results, and the results were used repeatedly to show that there in fact was not election fraud. So we keep saying it. We keep saying there was no election fraud, like obviously, but the only reason we were able to convince a substantial number of Republicans that there was no election fraud is because of those cases. So if we're saying no lawyer should have taken those cases, we never would have gotten those cases, and we wouldn't have had the ammunition to come back and say, look, these are the facts. Our system is designed to produce facts. And while there have been a lot of ways in which Trump has blown through norms and undermined institutions, people still have faith in the courts. And so I think this was, the lawsuits themselves were great for democracy. And if they couldn't have found a single lawyer to bring those lawsuits, that wouldn't have been so good. So that's a way of saying I'm concerned about unpopular positions not having access to the court. And that's not to say there isn't some limit beyond which you cannot go, and maybe Giuliani crossed that line. But I would just be very, very cautious about putting the weight of the disciplinary committee and removing somebody's license over something like this. So that's my view.
I'm going to push back on this still. I'm going to turn to Ellen, which is to say, you're talking to the public now, let's say not just a group of lawyers and law professors, about the limits of the disciplinary system. People expect that if we regulate ourselves, we have a monopoly, right? And one of the concerns we say is that, okay, we'll regulate ourselves, and here you have conduct that, let's say, is not on the margins. This conduct is way over anybody's margin. Why? What do you say to the public, Ellen? If we don't discipline lawyers, why should Giuliani get to keep practicing law? Why should Sidney Powell or Lynn Wood get to keep practicing law? I mean, judges' sanctions aren't going to do anything about it. Don't we really need to take seriously at some point the notion of discipline. Ellen, you want to deal with that?
You know, I do want to talk about that. And I was glad that Bruce brought up the preamble, because the preamble to the rules of professional conduct are, you know, kind of part of my favorite place to look for the definition and the meaning of who we are as lawyers. You know, the preamble starts out by saying a lawyer as a member of the legal profession is a representative of clients, an officer of the legal system, and a public citizen having a special responsibility for the quality of justice. So, you know, wouldn't it be wonderful if really that was our reputation? Because I do think that as lawyers, professionally, our reputation has been, you know, kind of maligned. And what we have seen here hasn't, you know, in the past few months with lawyers bringing these cases, and, you know, even lawyers who are acting outside of their roles as lawyers, you know, Josh Hawley and Ted Cruz, has really, I feel, tarnished our reputation. I mean, when I see Josh Hawley and Ted Cruz, I feel, you know, I think to myself, that guy's a lawyer. How could he act this way? And I completely agree with both what Rebecca said about we have to be very careful about not politicizing the disciplinary process, and what Bruce said about the disciplinary process itself is inherently opaque and slow moving and doesn't really, you know, we don't kind of know what goes on. It doesn't satisfy, you know, the public's demand for, you know, let's make sure this misconduct is addressed promptly and, you know, appropriately. But I don't think that means we should give up on the disciplinary process in this case. I mean, I represent.
When you say this case, I want to stay away for a moment from Hawley and the Senate people.
I agree. I just mean in this case of the lawyers who brought these cases. I completely agree with Rebecca's point that, you know, yay, these cases were brought and we won. But these arguments we have not persuaded 74 million Republicans that this election wasn't stolen. That they, you know, we persuaded some people, but I saw something today that said like 83% of Republicans believe there was election fraud. So, you know, it not only did it, I mean, so there's kind of both sides to that. It both demonstrated that these claims were frivolous, but it also in some ways lent them legitimacy. But I also think that, you know, what Bruce said about the purpose of discipline, and each system is different and the way it's enforced is different, but it's to protect the public, preserve the integrity of the courts, and also deter unethical conduct. And, you know, I think it's important to me as a person who represents attorneys, you know, who are, I mean, it's not, in my practice, I am not seeing only the most egregious misconduct being either complained of or sanctioned. You know, what I see is a lot of lawyers who are getting sanctioned for things that, you know, are nowhere near what happened here. And so I think it's both an equity issue for the disciplinary system to say, you know, it's not the high profile lawyers that aren't going to get punished, that we're going to treat everyone equally. We're going to look at this conduct as if it's, you know, whatever, you know, Joe Schmo who's brought this complaint. And it is true that there's a lot of Rule 11 cases that don't get picked up by disciplinary authorities, but I think that's a measure of limited resources. So yes.
I just want to say something. I just want to say one word about the First Amendment here, because, you know, part of the thing is that when you look at those statements that are in the complaint against Giuliani, the vast majority of the false statements that he is accused of making are in public. They are not in court. In fact, the one thing that he said that was untrue in court, he took back. So I just want to make a point about that, which is that we have these rules about honesty, but we treat them very differently. And we give much more leeway to attorneys representing their clients in public. And there's a reason for that. And that's because attorneys, the First Amendment and attorneys are really complicated because attorneys are basically playing two roles. On one level, they're officers of the court, and as such, they're kind of, subject to a great deal of regulation, but they are also challengers of the government. And in that way, there are classic political speakers. And so, I just want to put us all in a moment in which there is, just imagine it some other way, in which there actually was election fraud, and everybody is kind of, this government is stacked against you and is stifling this particular view. And it's a true view. And how are we going to get that out if we deter lawyers from ever taking on this kind of case that is, disfavored in this particular sort of way? And the history, the history of lawyer speech and the cases that are about protecting lawyer speech are always about groups that are marginalized and weak. So to the extent that I know it's like, you're like Donald Trump, like he doesn't need, you're calling him a disfavored position, but you just have to be careful, because if you don't protect, if you don't look out for this in this context, you're not going to have it when this comes around the next time and this lawyer is protecting some group that you have sympathy for that is a lot less strong and capable of protecting itself.
Okay, so I was going to wait to open up the discussion about First Amendment outside. I'd like to try to do this one thing at a time. Okay, so I want to start with in court, complaints in court, and distinguish those from First Amendment speech in the public sphere. So Dennis, a number of the complaints, many of the complaints filed are about conduct in court, correct? I just want to say correct, yes? All right, so now Ellen, I want to turn to you about the point that Bruce is making about judicial sanctions. So tell us about judicial sanctions, because the argument being made is that ought to be sufficient, right? Judicial sanctions here is the way in which we regulate lawyers in those kinds of cases.
Yeah, and I'm not necessarily arguing that I think judicial sanctions aren't sufficient. I mean, certainly if I was defending a lawyer that was sanctioned, that received a Rule 11 sanction and then a disciplinary complaint, I might argue in mitigation that he'd already been sanctioned for that conduct and that this is a double sanction that's not necessary. So let
me just say again, we have either we have a myth or we ought to accept the fact that discipline is really punishment, right? We have a myth that says sanctions serve a different role than the lawyer disciplinary system. The lawyer disciplinary system is about self-regulation of our profession. And if what we're saying is, well, sanctions, discipline, it's all the same thing, just put it in a pot, right? A big pot. Maybe we ought to rethink the entire disciplinary system.
Well, I mean, what's interesting about the myth is what's the difference between deterrence and punishment, right? Like if you say our purpose is not to punish, but our purpose is to deter. Well, how are you going to deter? You have to deter by some kind of sanction, which is punishment. So I don't know if that kind of responds to your point, Ellen. But certainly, Rule 11 says that the purpose of Rule 11 in the commentary says it's to deter. And so, that the sanction should be appropriate to deterrence. In the Detroit case, that is, has been the subject of some publicity recently, and that's the case, I think it's King against Whitmer. And so in that case, that was filed, I'll just talk about it briefly. It was filed on the Wednesday before Thanksgiving. It wasn't served until December 1st. And it asked to decertify basically all the electors and basically throw out all the votes in Michigan and permit the Republican electors to be sent to Washington. And the court said, so it lost on all these grounds, 11th Amendment immunity, mootness, latches, standing, things that you don't generally see all at once in federal court. And the court said this lawsuit seems to be less about achieving the relief plaintiffs seek, as much of that relief is beyond the power of this court, and more about the impact of their allegations on people's faith in the democratic process and their trust in the government. So the court is really, in its opinion, I think, inviting a Rule 11 motion, saying this is not brought for the purpose for a proper purpose. And Rule 11 is really comprehensive and lays out, the requirements for pleadings and motions that are filed in federal court. And by filing or advocating a position in federal court, the rule basically says that you're making certain representations. And so the representations are that, you have facts to back up what you're saying, and you have some reasonable interpretation of the law. And if you don't, you will be sanctioned. And there was also a claim under 18 U.S.C. 1927. There was sanctions sought under that statute. And that's a statute which permits the litigant to go against the attorney and make the attorney personally pay for any fees that are created because of vexatious proceedings, who has multiplied the proceedings in a case other than reasonably and vexatiously. So the purpose of that sanction is clearly to punish, and that's what the courts say. This sanction that makes the attorney himself dig into his own pocket and pay the fees of the other attorney for the proceedings that he's brought, that's for punishment. And so, and there's been, so the motion for Rule 11 sanctions also requested that the attorneys be referred to state and federal discipline. So, I mean, the issue is, if there are facts to support a case, and if there's some kind of reasonable interpretation of the law, then you won't be subject to these Rule 11 sanctions.
Well, these are unique. I mean, these aren't, as Bruce says, there's volumes written about Rule 11, right? And
Yeah.
lawyers can be on the margin of Rule 11 or not. There's nothing about this that's on the margin of decent conduct, right? I mean, these are clearly frivolous. I think we agree, right? These are clearly frivolous cases. So, Bruce, I'm going to ask you, because you're not in favor of using the disciplinary process for these kinds of cases, right? Does there ever come a point where the cases filed here are so frivolous that you think a disciplinary system should get involved and say a lawyer who does that should be sanctioned through the disciplinary process?
So I don't remember actually taking the position. My position was that in fact, this is a descriptive point, that the disciplinary process doesn't go after Rule 11 for the most part. But there are cases, and I think they're right, where someone's a serial filer of frivolous lawsuits, and particularly if they're doing it for the extortion value, and we've seen that. Those are pretty good candidates in my book. I'm just saying the run-of-the-mill case where on a one-off basis a lawyer files something, and in retrospect you go, whoops, there really wasn't a basis for that, may be sanctionable under Rule 11, but not typically in the disciplinary process, not because there's not a rule, but because disciplinary authorities exercise discretion. Now, one of the points I want to make about Rule 11 is you get to take it back. So it actually has procedural provisions where if you withdraw your frivolous claim within a certain amount of time after the complaint is made, you avoid sanctions. And maybe that doesn't avoid discipline, but that's kind of ironic, since most of us would rather pay a Rule 11 pocket change than we would have our license affected. But the other thing I want to say about this particular context is think about the timing. So in an ordinary case, if you're filing a complaint, let's suppose you have a 3 or 5 year statute of limitations, you do a lot of investigation as much as you can informally without violating, Rule 4.2 or other rules that restrict what you can do. But to the extent you can, you talk to your client and you talk to witnesses and you gather what documents you can, and you make a judgment, and you don't file something until you have a non-frivolous factual and legal basis for doing it. Here, it's now or never. Don't you think that if you want to test the legality of an election and it's going to be certified on January 6th, and election day was, on the first Tuesday after the first Monday, et cetera, you don't have a lot of time. And so if there's any context in which you should give people a bit of a break, and I'm not defending them, I'm just saying, I think as Rule 11 goes, this isn't the strongest candidate for sanctions. And beyond that, if it didn't matter enough to the defendants to litigate Rule 11 sanctions, why would the disciplinary authorities, in my state, sad to say, and probably in some other states, we have a lot of lawyers who are doing, committing felonies and stealing clients' money and doing things where you really do want to protect the public from these folks. Do you think that Rudy Giuliani is going to be hired to do a lot more cases where he's going to file frivolous complaints, assuming the one in Pennsylvania was? And let me say something about that assumption, Ellen, that I'm making. There's a due process issue here also that all of you would recognize in other contexts. There's nothing wrong. I see no problem with Dennis's group, filing a complaint and letting it be adjudicated. But I think there's a lot of people on the chat who've already adjudicated these complaints. And I have to say about the chat that any one of the people who've been chatting could be on this panel because it's a very most distinguished group of chat.
Great chat. I can't even ask people to comment on the chat because the chat's so great unto itself. But so Dennis, let me turn back to you. So Bruce, the academic, somebody commented to me like, there's such a division between the practitioners and the academics on this panel. It's so obvious, all right? So you've heard this. I mean, maybe not Rule 11, but you're talking about making false statements and other allegations that are clear violations to you. If a judge had sanctioned any of these, right, would you still have filed complaints? Do you still think there's a role for the disciplinary process to play? And I'm talking about in court. We're not even moving out of that yet. We're staying in litigation.
Well, we don't know what's going to happen in Michigan. They just filed, I mean, other than Powell filed, and by the way, there is a couple of things that she said in her response, which were just not correct, that she didn't sign the pleadings and that it only applies to people who sign the pleadings. She's interpreting an old version of Rule 11. Her cases are no longer good cases, which I think is really adding insult to injury. I mean, for me, part of what's sanctionable here is the incompetence. That is really what has been grating on me in all of these cases. But sorry,
Ellen, not to put too fine a point on it, but one of the more remarkable allegations against Sidney Powell is that she said, I didn't actually sign the complaint. There's just an SS and, it went in under my name. Therefore, I'm not liable. Now, actually, that may be correct. So let's just leave it that way. That may be, in our discussion before this call, we talked about that. So we don't.
It's not correct under Rule 11. She's talking about the old version of Rule 11 before the 1993.
Whatever. I don't want to get hung up in the weeds on this. I want to turn to Dennis. So Dennis, what do you think? If judges would actually do what they are supposed to do, the judges don't like to impose sanctions, right? We know that as well. So if judges impose sanctions, would you still think that you would be filing disciplinary complaints in these cases?
First, I want to say that listening to the academics, I never thought of these things, and I'm going to recommend to all the signers that they withdraw the complaints. Just kidding. The answer to your question is, it's a great question. And what it makes me think is that if the judges had sanctioned, then the punishment function would be served, and you would look very, very carefully at whether or not the protection of the public function had been served. I want to say to Bruce, if the court doesn't, if the defendants, you asked, if the defendants don't file the complaint, well, there's a deterrent on filing requests for sanctions. And it's called counter requests for sanctions, even if they're frivolous. They were frivolous. Now I'm going to file a counter. So a lot of people don't want to get too involved in that, especially with lawyers who show some indication of a lot of passion, let's just say, maybe not a lot of balance. Another thought I've had, and Ellen, I'm going to count on you because I get carried away, so to stop me.
I'm really good at interrupting people.
Yeah, good. Please, I welcome it. But Rebecca's made this interesting point, and it's really true that there are different standards in and out of court because of the First Amendment. The Giuliani case is really interesting in that respect. It's almost the considerations all, upside down, standing on their head.
What do you mean?
Giuliani-
Because there are complaints in court and then the same ones outside of court, right?
Well, there are complaints in court, and there's behavior in court, and then there's behavior out of court. So this is the simple version. I'd love to talk about Giuliani's complaint. I mean, it's so amazingly stupid that you got to think about how frivolous it is. But I'm not going to do that. But in court, as Becky said, he says, yeah, there's fraud, but then he corrects himself. No fraud, no fraud. And then he's in front of a federal judge, and he knows what the limitations of what he can do with a sanctioning authority right there in front of him. And he also knows that the First Amendment and the lack of much action from disciplinary authorities when lawyers are acting in the public square. And so he goes out of court and he says, this is the greatest crime I have ever seen. And I've seen a lot of crime. And then he says, and there's no question about it. All these Democratic bosses, you think that they did this individually? This is a conspiracy of all these people. And guess what? They did it in the Democratic cities where the judges are all hacks. That's his word.
Okay, so Dennis, the point, I think.
Well, my point is that this is a case that's kind of standing on his head because he goes out and he feeds the narrative to the public through weekly YouTubes. He feeds it through press conferences, but he won't dare do it with that judge staring right down at him.
So the point you're making, and maybe we'll now go to the First Amendment
Hi,
elsewhere first, is
I'm
that,
here for cartridge exchange, but I wanted to ask, I saw the sign about smartphone battery replacement.
excuse me, I don't
Did you
know,
replace batteries in smartphones?
I don't,
Well, you don't know. There's a sign.
Zoom bombed.
All right, I'll
Zoom
go
bombed.
after I take care of this.
Ellen, now you're muted.
We're all muted.
unmuted, okay, I'm unmuting, you that was interesting, okay,
A commercial break.
really. So Dennis, what you're saying, and this
Yeah.
really is a
It's
very,
Pretty too, because we go back and forth and
I don't know what
it was,
this person. Judy,
yes,
all right.
actually, right. Thank you for asking, because people
Okay,
don't always ask, and I
we're gonna see what we're doing, okay.
That's it.
We were going to go, I was going to go to government lawyers first, but let's talk, we might as well talk about the First Amendment. And it's really complicated because someone's asking questions about trial publicity. So, that's a First Amendment issue as well of sorts. And we have different rules for lawyers outside of court than we do in court, right? And Becky started alluding to that. But what you're talking about, Dennis, is they're sort of intertwined. That what Giuliani does is he makes false statements in court, right? Which we've talked about in terms of potential sanction. And then he goes outside of court, uses what he did in court, right? And uses the public sphere. So Becky,
It's not the false statements in court. He had a very different claim in court. He didn't make he refused to make the false statement in court. He only made the false statement out of court.
Can I ask Dennis a question, Ellen, about this? So it was would it make a difference in your view if he was or was not representing a client? Because, there's a lot of, loose or / false talk about the election that came from people, on cable news or whatever. Some of them were lawyers and some of them may not have been representing a client. He was representing a client, at least at some point in a case. Does that change the applicable rule in your view?
well, my view or Dennis?
I'm asking Dennis because he submitted the complaint against Rudy Giuliani.
Bruce, I'm not 100% sure I'm clear. To me, about your question, so maybe I need more clarification, but, you do have to consider the fact that he's representing the president of the United States and he's making these claims. And I'm sorry, I can't help but keep in mind that these are the exact claims that, are fueling insurrection in the United States and that people are believing because the president has invited them there. And this is his lawyer saying the same thing. And he gets up on the podium and says, let's have trial by combat. Well, I guess that's protected by the First Amendment.
Okay, so what I want to do now is, because we've raised the First Amendment in a variety of contexts, Bruce or Becky, Becky, why don't you do this? We want to lay out the differences between conduct when you're representing a client, First Amendment conduct, and the limitations of that in the courtroom, or trial publicity, then comments when you don't represent a client, in or out of, well, you wouldn't be in the courtroom, outside of it, which is to say, we want to distinguish between pure speech, if you will, for lawyers, and what the limitations are, if any, on those, right? In terms of engaging in dishonesty, deceit, fraud, misrepresentation, if we want to go that far, versus conduct in the courtroom.
Sorry, my dogs. So there are multiple rules. And I mean, I think, again, this is a group of people, many of whom know all of these rules, but I'll just say very quickly, the most broad rule is Rule 8.4C, which says a lawyer, and I'm referring, every state has different rules, obviously, but I'm referring to the ABA rules. And, a lawyer can't engage in deceit, dishonesty, misrepresentation. That is hugely broad rule, would apply to all of the people that Ellen just mentioned, somebody on TV, a lawyer, a politician, a lawyer in court, everything. And then there's Rule 4.1 that addresses your honesty, the inability to make a false statement of material fact while representing a client. And then there are rules about what you can say and can't say in court. But I think the most important thing to realize is that there are times at which the Supreme Court has talked about the First Amendment and lawyer speech. And it has, there's basically a gradation about, when it is, when a lawyer is engaging in a kind of political speech that ought to be protected, and when a lawyer is acting as an officer of the court and is most susceptible to regulation. And so the speech that you make in court, I don't think anybody has any problem with, disciplining a lawyer for saying something in court that is not true. But it gets a little bit more complicated when you're on those courtroom steps, right? Representing your client, saying something, my client's entirely innocent. That was the topic of the Gentile case. Is that going to prejudice the jury, as 3.6 says? Is that a material misrepresentation? There's definitely, I think, a consensus or close to consensus that we ought to be more careful about a client spinning the evidence on behalf of a client outside of the courtroom. So, I actually think, just getting back to the broader point that Dennis mentioned, lawyer regulation is not working terribly right here. Rudy would not lie in court, right? I mean, he seems so not with it, but he was able to notice that the court was pushing him back into the corner saying, are you telling me this is a case about fraud? And he was like, oh, no, I'm not saying that. And he knew it. He knew this is a line you can't cross. And that's a sign that regulation is working pretty well. And so, I don't know. I know that he has said egregious things, and I know that, there are ways in which it has fueled a situation in this country that's dire. So I understand Dennis, and Dennis is upset about it. But what we do about that, first of all, whom we blame, I think the main culprit here are not the lawyers, whom we blame for that, and what we do about it is another question. And I also want to clarify before, just because I'm speaking right now, I, like Bruce, was not saying I think discipline is the wrong way to go. What I was saying is I think we need to treat discipline very carefully so that we are not disciplining these people in any way, in any different way than we would an ordinary person, because that's when the use of discretion scares me. If we're using our discretion to go after a political enemy or the lawyer who's representing a political enemy, that's concerning. If you can fall back and say, this is the same way I treat every other lawyer under these circumstances, that is a reassuring thing to do. And that's why these complaints are masterful, because they're not actually, they aren't just screaming. They actually are citing rules. They're citing them in context. They're very careful. And so I just want to be very clear that I am not making a blanket statement about the use of the disciplinary process. I am just saying, I personally think we ought to stand back and be very, very cautious about using it. It doesn't mean never, and it doesn't mean it's not appropriate here, but I'm voicing the caution because of the concerns that I think are hard to see in the moment and easier to see when you're looking historically or looking into the future.
So I think Dennis started by saying, and with his principles, of course, you have to exercise caution, which is why these are drafted so carefully. But I do not see here, Dennis, maybe you want to comment on this, that we're treating these people, Giuliani, differently than, quote, normal Giulianis. I don't know what a normal Giuliani would be here. I mean, this is a pretty abnormal set of circumstances. And, you know, of course, there's caution because we don't want to, you know, over criminalize, if you will, or over punish, certainly not First Amendment speech. But does there come a point where it was, you know, in the lingo we talk, the 8.4C lingo, where the misrepresentations and the falsity is so extreme outside of court that we would think a disciplinary authority should engage in some.
So I want to let others answer that because I just spoke, but I do want to say, just linking it back to the conversation we were having about Rule 11, the reason why I agree with Bruce that we really need to look at, you know, to say this is not how it normally goes, right? Courts are right there. They have access to the evidence. They're in the best position to assess whether something is frivolous or just really sloppy or just really, you know, weak. And so since disciplinary committees tend to stand back on this issue, I don't see why they should act differently here. That's what I'm trying to say, is that we, as to the extent that we can compare similarly situated cases, we should.
Ellen, what do you say about the First Amendment outside the courtroom piece here?
So I think, I mean, I'm not a First Amendment expert, but, you know, I do think that when he goes outside the courtroom and is talking about the case, you know, Rule 3.6 is implicated, the rule that relates to publicity, but also he is acting as an attorney. And so he, you know, he's not just making a random public speech. He's acting as an attorney advocating a position. And I think 8.4C applies. I mean, what's interesting thinking about all the caution that's been expressed, which I think is appropriate. I think disciplinary authority should always be exercised cautiously. You know, the lawyers that I represent, when they get a complaint, they are devastated. They can't sleep at night. They immediately fear, even if I'm looking at the complaint and I'm saying to them, A, this is going to be dismissed, or the worst is going to be some kind of private sanction, they immediately fear losing their licenses. So, you know, and that to them, for, you know, for many of us who are lawyers, you know, being a lawyer is part of your identity. It's part of who you are. It's just, it's so integral to our souls in some way. And so I agree with the premise that the disciplinary authority should use appropriate discretion and really focus on bad conduct. Like Bruce says, people who are committing felonies and stealing money and, you know, doing other things. But so, you know, on the point of, if this wasn't Giuliani, let's think about that. If it was some other lawyer, you know, just filing these lawsuits that have no merit and no basis and creating, let's not say a political harm, but this level of harm, a high level of harm, we would want that lawyer disciplined. Because one of the things that the disciplinary board looks at, and the Office of Disciplinary Counsel in Pennsylvania at least looks at, is what is the harm that is created by this lawyer's misconduct? That's one of the circumstances where you're judging whether or not you're going to, you know, use the discretion of imposing discipline or investigating a case. What's the harm involved? There was great harm here.
It's the harm to the public, right? It's not stealing an individual's money, but it's the harm to the entire profession that claims to be self-regulating, right? We have to keep going back to that. I think, Dennis, that's how you started, right? I mean, do you perceive that as the harm?
It's the harm to the public and to the profession and to the profession's reputation. That's what it is. You know, that's where it lands for me.
So Bruce, do you agree with that? Go ahead, Dennis.
Well, that's where the egregiousness, I think, you know, comes into play. And I want to express my appreciation for the cautionary note, of people who think about these issues a lot more than I do. And I get carried away by, my passion when I see someone trashing the rule of law, for example, who happens to be the top law enforcement official in the United States, Bill Barr. That really offends me. And so it's good to hear a cautionary note about those things. It comes to mind because we did assert Rule 8.4C, the rule that says lawyers shall not be involved in conduct and should not commit conduct involving dishonesty and misrepresentation, because Bill Barr he wasn't in court, he went to the Senate Judiciary Committee. He was under oath. Does that matter? Probably. And he basically was asked, why did you absolve the president of the charges of obstruction of justice that the special prosecutor had laid out all this evidence about? And he basically misrepresented the law, and he basically misrepresented the facts. He treated the facts, I won't go into the detail, but he acted like a defense lawyer for Donald Trump. He did not act like a prosecutor representing the interests of the United States, which is what his duty is. And he totally misrepresented the law about obstruction. And these are misrepresentations outside the court. I got to say, when the chief law enforcement official just trashes the rules around a profession that I loved being a prosecutor, and this guy is doing this to destroy our democracy, I have a hard time restraining myself. The good news is, and I'll finish, is that I had some people restraining me, and they were professors in this area, and they would tell me what was right and what was wrong, and that was very helpful.
So you filed a great complaint against Barr. Let me ask you, there's a great chat going on here. I keep wanting to go back and forth to people on the chat, but in terms of the Barr complaint, one of the questions asked early on is, what's your expectation? Are you ever going to find out what happens with that, what they do?
They disciplined Larry Klayman, who was the head of Judicial Watch, but I think it took about 1,000 days. It took 3 years.
Right.
And so I'm not, I lose my sleep about a lot of things, but I don't lose sleep about that. But yeah, I think, we think about whether we should ask a question. We don't think we're going to get much of an answer. It's a confidential process. And I'll just confess something else. I had dual motives myself when I came up with the idea. And one was the guy should be disciplined. And the other was, I hope I sometimes confess this to the people who are advising me, but I thought it would have some restraining effect on him that, all the stupid op-eds I've written, didn't seem to do anything. And so I thought this might have some effect on him when he was thinking about the October surprise that was coming from U.S. Attorney John Durham, which for a lot of reasons never came. And I think that complaint might well have been part of it.
Well, I'm glad you're so optimistic in thinking that. I'm sorry, I don't think it probably had an impact upon him whatsoever. But so it raises the question, I think, that Becky probably wanted to talk to, or maybe Bruce, about the way in which the public figures like Barr are really taken to task, and whether the disciplinary system is really the appropriate way to do so, or whether it's really about elections or something else. Becky?
So this is what I was going to say, and I think I will push it with regard to Barr. And again, I thought that complaint was great and masterful and well done, as you know. So I am not complaining about your complaint, nor am I giving an opinion about how they should rule. But I just want to say,
Becky, I can't wait to hear the other shoe drop. I hear that other shoe about
okay.
to drop.
So let let me just put it this way, because I think we need to play devil's advocate with ourselves, because we tend to speak to everybody woke up in morning 2016 and we were like, wait, what? Because we tend to speak to each other more than we do to people who have different views. So I want to say this: what if you're Bill Barr and you think that the country's interest is Donald Trump's interest? You think that the other side, the people who are putting forth these, crazy ideas about identity and race, the making up stuff, you think they are a real threat to America. And you also think that they've infiltrated your department and that they started this completely unfair and unjust investigation into the president to hobble him, to basically make it so he couldn't do his job. I think if you put yourself in the shoe, what do you do if you're that AG? What do you do if that's your view of a reality? Now,
I'm going to tell you what you don't do. I'm going to tell you what you don't do.
Right. Hold on. I still think that he did things that were wrong. I don't think you can go outside of the normal processes in order to address that. I think there are ways in which you should address it, and that's fine. But if you take that view, there is a consistent line you can draw between him. Exactly what he did with regard to everything that you complained about was all about the Russia probe. So when you think about it, if he thought the Russia probe was invalid and illegitimate from the get-go, he was trying to single-handedly, in a vigilante way that was not appropriate, dismantle that, but otherwise was fairly concerned about the institutions of democracy. It also gives a perfectly acceptable, if not very sympathetic explanation for why he did exactly what he did wrong and what he did right. It's consistent. He thought he was serving his client, the United States.
I want to stop you because I don't really want to get into that discussion. I want to be a panelist here.
Can I be a panelist?
No, I'm not a panelist. I totally disagree with that, but whatever. I don't want to get into the weeds about Barr, right? We're looking at, and Becky, I don't mean to be disrespectful, but we're really looking at what the role of the discipline system is, right? His position is it's like Sidney Powell. Sidney Powell standing up and deciding, well, the whole thing's fraud and operating from that perspective as well. There's a point that where reason really matters, and I think Barr's outside.
So can I jump in, Ellen?
Oh, no, of course you can.
Okay. So I want to go back to maybe Rudy or Powell or Linwood, all the people who are talking in public about this stuff. I think I asked a question of Dennis, whether he was thinking of this differently because Rudy was a lawyer in a case. I would just as a footnote before I get to the point I really want to make is, if you're thinking about him as a lawyer in the case, then I assume the rules of the District Court of Pennsylvania apply, even though he's subject to sanction in New York under the New York Choice of Law rule. I assume the relevant law would be Pennsylvania law. And I would note that if we're really thinking about his transgressions on the courthouse steps or at the Four Seasons or wherever it was as being what we're focusing on as being connected to the case, then I kind of would ask, the judge didn't care. Why do we care? So it raises the same sort of issue as the Rule 11 issue. But to me, I wasn't even thinking about it as being connected to the case, because I'm sure, he was only involved in one case. I'm sure before he was involved in the case, long after the case was over, he was saying the same stuff about, election fraud that Dennis says is all lies and should be sanctionable under 8.4C because, as Becky says, dishonesty, deceit, fraud, and misrepresentation. So that's the question I wanted to address. And I wanted to say something that I haven't seen said before, which is, let's suppose that it was 2015 before this whole national nightmare occurred. And someone said to the New York courts or the Pennsylvania courts, I think we need a new disciplinary rule. And what the disciplinary rule ought to do is say to people who are talking about federal politics and federal elections, these are the lines you can't cross. And even though politicians who are not lawyers can get 4 Pinocchios, we know that politics is filled with misleading statements and false statements and all kinds of stuff and spin and whatever you want to call it. It's all on a spectrum from, honest to completely fabricated. We want to draw the line differently from lawyers. If they want to give up their law license, is fine, but as long as they're still lawyers, we need to draw a line and somewhere and say, you guys can't say misleading things. And I suspect that most state courts would say, we don't want to get into it. We don't want to get into it because of federalism issues. It's not up to the states to regulate federal politics. It's not up to the courts to do it. If the courts do it, we're making the rule, we're then investigating, we're enforcing it. That we should not be doing that when it comes to politics. And so that's in effect what we're saying they're doing when we take a state rule about dishonesty and deceit. It's not so clear how it would apply in the political realm, in the court of public opinion, et cetera. It raises First Amendment issues, yes, which is another reason why courts shouldn't get into it. But it's also not the state court's role, I think, if Congress can, assuming it can constitutionally do it, say something about what federal politicians should be saying, that's fine. If state legislatures want to say that about state, politicians, that's fine. We saw in Minnesota against White that there's limits, on what, the legislatures or the courts can do when it comes to judicial ethics. And judges, if anyone should be restrained, it's judicial candidates much more than Giuliani, Powell, and everyone else. So I think I've kind of made my point, but I just think this is a really questionably appropriate or maybe not appropriate area for state courts to get into using their disciplinary power.
Bruce, that leads the one piece of this was the Hawley Cruz piece, which is to say, it's exactly what you're talking about. Should state disciplinary systems get involved in that, or should we leave it to the Senate Ethics Committee or elsewhere, right? I mean, that's one question raised by this. I don't know, Dennis, if you want to take that, or anybody does, but that's part and parcel of Bruce's question. I mean, I push that even further and say, so are we back to saying, we have to be really narrow about who we discipline. Let's just discipline a lawyer who takes money from clients, who repeatedly doesn't return telephone calls, who repeatedly does things in court. But let's stay away from prosecutors. Let's stay away from public figures. Let's stay away from big law firms because they discipline their own. So let's just go after the little guy, which is really what we do in our disciplinary systems. And if that's where we are, why don't we just say so? Anyway, Dennis, I'm sorry, I went off. This is my view as moderator / panelist, apparently. I'm not being a great moderator. Dennis. Now, this is I want to just talk about the Hawley, Bruce's point, right? The Hawley Cruz point. Do we just leave that to the Senate Ethics Committee and say, no, these complaints that have been filed against them in Texas and elsewhere shouldn't be filed?
It's a great question, and it puts, my own motivations. I ask about my own motivations. Oh, the Senate Ethics Committee, they're sure going to do something, aren't they? And so that makes me realize, well, I just can't stand this conduct, and something needs to be done. And that's the reason that, Bruce and Becky are good cautions on me. This is the first complaint, as far as I know, ever in the history of the Senate of an ethics violation filed by senators against other senators. Guess how far it's going to go? It's not going to go very far.
Sorry, I didn't mean to interrupt.
No.
But I would say, if we start holding lawyer politicians to different standards than regular politicians, then lawyers aren't going to become politicians, and I don't think that's really good. So I think, there's a concern if, again, if they did something out of the realm of what's acceptable in politics, by all means, and maybe that's the Senate complaint, and I'm okay with that. But I do feel like a complaint that alleged professional misconduct under the professional conduct rules would be slightly problematic, because then if you're going to politics and you happen to be a lawyer, you're held to a different standard.
The good news, Becky, is that the oath is pretty much the same oath. So you could The only difference is they took 2 oaths, not just 1 oath, that non-lawyer politicians take to support the Constitution. I mean, Hawley's role in the insurrection, I think, is pretty evident. And, he's the one that's pumping his fist to the crowd. And then I'm not sure what he did, actually. I heard Jack Danforth say he actually didn't speak up when it came time after the insurrection. And I haven't looked at that. But I think that, with that conduct, the conduct is about the violation of the oath. And so your question is a good question. Well, is it any different from the oath of that other Congress people take? Probably not.
So, but I think on the April chat, I think it was Richard Zittrain or somebody who pointed out that the oath itself is a rule in some jurisdictions in DC
Right.
and in California. It's not in other places. So that was the grounds upon which they filed against Hawley and Cruz.
I don't know what it is in Texas. Cruz is in Texas. I've heard that there may be some disciplinary complaint against Cruz sometime soon.
Ellen, what do you think about this whole question that we're talking about? Should the state disciplinary systems get involved when we're talking about federal political people? And that includes Barr, in fact. I mean, Dennis, I think I include Barr in that as well.
So I believe that lawyers should follow the rules, wherever they are. And that, when we're talking about, if you're holding a lawyer, I agree with Becky's position that, if we hold lawyer politicians to a higher standard, they won't want to be lawyers, but maybe all politicians should be held to the standard of having to tell the truth, and that lawyers should also have to tell the truth all the time. Maybe that's naive or impossible to enforce. But I have represented at least magistrate judges who have gotten in trouble for lying on in different contexts, and so I don't feel there's anything that's antithetical to our system to have lawyers who are politicians held responsible by the governing bodies of lawyers, the disciplinary system, hold them to account for those lies or those actions or their violations of the oath they take as lawyers to protect the Constitution. I do think that, some of the points that you raised, Ellen, about, the failings of the disciplinary system, which have been mirrored by the comments of people who also represent respondents on the chat. I think we should not say, okay, we just have, a small and solo disciplinary system and accept that. I think we should say the disciplinary system is, working in certain ways, not working in other ways, and we should address it and we should fix it. And, part of the reason why it's mostly small and solo firms who get dinged by the disciplinary system is because they're handling money. Big firm lawyers never see money. So, I mean, that's a big part of what happens in disciplinary cases is they're going after people who, mishandle money. And so, there are ways to kind of fix the disciplinary system so it can handle these issues. I definitely do think that the kinds of conduct that we have seen in the cases that we've talked about should be disciplined. And I definitely feel that, Ted Cruz and Josh Hawley have a higher responsibility as lawyers to uphold the law and can be disciplined for their failure to do so.
Becky?
So, I mean, there's so much to say, and I'm reading the chat, and it's so interesting.
I want to say this is the best chat I have.
It's like I feel like I'm missing out on the chat.
It's
I'm
like
trying
all
to pay
great people making great comments.
Right.
I'm going to save this chat. I think we could publish the chat.
Right.
Fabulous.
So a couple of things I wanted to say. One, in response to the question of disciplining somebody under that state rule for not upholding one's oath to support the Constitution. I mean, that one scares me. I mean, Dennis, you really did. You started with talking about the McCarthy era, and you can't. Just because you raise a fist to a group that you have some sympathies with does not necessarily mean you're saying to that group, like, and by all means storm the Capitol. And there were lots of lawyers who were sympathetic with many of the goals of the communist movement, but were not themselves advocating the overthrow of the American government. And I do think there should be room for people who have a great deal of sympathy with a group and then don't buy into their hideous, awful tactics. Now, we are going to end up in a world where there are people, doing things and lawyers doing things to support, if we're fair and principled about applying that across the board, not just to the, communist movement and Black Lives Matter, but to every group, even those we disagree with. If we're principled about it, then we're going to be in a world where we coexist in a bar with lawyers who we feel are pretty abhorrent. And so I guess I'm okay with that, because I don't think you fight illiberalism with illiberalism. I think you fight illiberalism with democracy and democratic institutions. And that's why I was like, lawsuits challenging the election, I love that, right? Because that's the way we show, like, this is wrong, this is illegitimate, this is where you're going through these processes and you're losing. So, that's where I come out on these points. I do understand where Ellen's coming from and Dennis is coming from. They stand up and they're a face for the profession on a certain level, but I don't know. And I also share Bruce's federalism concerns, because I think, you could have a state, I know it's become absurd at this point, the Democrat states and the red states and the blues, I don't believe that, but I do think you could have a state where the bar was captive of a particular, political party, and it went after a federal official who of a different kind of, and it's concerning to me. I don't think, in our federalist system, I think that ought to be, again, not never, but just cautiously used. And, I also thought what people were saying on the chat about the Thornburg memo and Reno was interesting too. And I'm sure Bruce could address that too. Of course, there are ways in which we have enlisted the states to regulate federal lawyers. But just because we've done that doesn't mean that it's sort of opened the floodgates to any kind of regulation at all.
But can I say that one of the things from the chat, and everybody knows, is that this is so far outside the realm of normal. Like Becky, I think Vanessa just said, but Hawley doesn't share your values. I don't care if we have Federalist Society lawyers that we talk to regularly. If they stay within not lying, right? If they don't lie in court, then that's okay. But once you go outside the norms that we've established, I mean, we spend hundreds of hours writing rules, right? And finding what the distinctions are, and trying to narrow in 8.4C because it's too broad. And we try to talk about what the First Amendment and how we do that. We've spent, and I mean, everybody on this chat, if we add up the number of hours we've spent doing that, we would have many lives matter. I'm just telling you, right? So what do we do about that part, right? That we really tried really hard to do that. And yet there are people so far outside. And that's how I think why Dennis filed these cases, right? People so far outside the norms that maybe the political process is not enough.
So I just want to say, Ellen, that you keep using the word norms, and I think it's very important to make a distinction between norms and rules. So insofar as people have violated the rules and the law interpreting those rules, I'm all for it. And I think Dennis has made a very good case in many of his complaints, and some of the other complaints do, that these lawyers have done that. And if they have, by all means. But I think punishing somebody for being outside our norms is concerning, because it gives so much discretion that you can create. I know you didn't mean it that way. I'm just trying to draw that distinction, because that's the line I care about. The one that I don't want anybody punished for not abiding by the norms I think lawyers should abide by. I believe in those, and I think they're important. And it sickens me also when people go outside them, but I don't think they should be disciplined for that. I think they should be disciplined for like the hard law violations. And that's why I love Bruce, because he always knows exactly, where that point is. And that's the line. We need somebody policing all the time.
Bruce, you know where the hard law line is all the time?
Oh, that was an endorsement. I owe Becky $5 for plug in my
So
Yeah.
talk
One of the things that Bruce Green said in a panel a couple of years ago at the ABA that has really stuck with me is these rules are a minimum standard. They're not what we aspire to. Not breaking the rules is not our goal. Our goal is to, as lawyers, is to do good, is to be better. So that may be, that's not obviously and that's the norm, right? That's the norm that we are aspiring to
But,
do well with our licenses.
So, boy, do I not like questioning something that Ellen says, but I think what Ellen Brodman. But I think what Becky would say to that is, well, what's good is in the eye of the beholder. And so that's why you stick to the rules. And I would say to Becky about norms and rules, yeah, I agree, but the slope gets real slippery when you start breaking norms. Then, you start cutting corners. It's all what integrity is all about. You start breaking rules. And I go back to the safe place with the Barr complaint. Bill Barr went in front of the Senate Judiciary Committee and he completely misrepresented the law. He said, black is white. Black is not white. That is a violation of the rule. It probably was our strongest case. The guy was under oath. He should be disciplined.
Right. And I think the point that I was making is actually that the rules are a minimum standard. And so if they are enforced fairly and evenly, if there's, what we talk about sometimes in criminal defense work, an equal distribution of justice, right? If it seems fair to everybody, that everybody is being investigated, sanctioned fairly and equally, then I think we're, I think we're okay. I don't think we are going to be abusing the system.
So can I
just say,
wait. I want you to address this too. We call them rules. We don't call them standards. We don't call them norm. We call them rules. Rules are not supposed to be broken. If this was your kid, right, you would say, this is my rule. If you break the rule, there is a consequence. And here, Bruce, what we're saying, you break the rule, well, sometimes a judge might get involved. Sometimes we think the rules should be enforced, but not really. And here are the 12 reasons. And partly it's because our disciplinary systems don't work. And is that what we're doing?
So Ellen, I have to laugh because the 50% of the time we talk about ethics, the other 50% of the time you and I and Rebecca talk about criminal stuff. If somebody said these prosecutors and the police, they ought to, every time somebody violates an infraction or whatever, they ought to be prosecuted to the hilt. You would say that's outrageous. In the other half of your life, you're talking about diversion. You're talking about discretion. Of course, we should have that in our disciplinary process as well. But I wanted to talk about a couple of
wait. You can't just get away with that. I'm sorry. You can't get away with that. We had this. No, it's because this is self-regulating. We're in charge of the profession. You want to open up the profession and say there ought to be criminal sanctions instead of rules of discipline for lawyers who violate certain things.
If you have a choice, Ellen, you could either have rules that are pretty run the gamut from don't steal, don't lie, to don't make an improper summation or whatever, or you could and there has to be discretion, or if you take out discretion, then you have to get rid of the stupid rules. So which is it? I really don't believe that you want to have the disciplinary process go after every lawyer who makes an improper argument on summation. And I think you could think of other examples.
I'm not suggesting everybody, come on. I mean, there's like a come on at some point, right? This is a rule. This is serious. This is serious. We all agree it's egregious. And it sounds like you're arguing, well, there ought to be something else here because it's politics or it's the public.
I didn't say that. I don't know why you're putting these words in that. I wasn't even putting it in the context of any of these complaints. You asked me, you said, don't you think as a self-regulating profession, we should enforce every rule through the disciplinary process? And I would say, no, not the current rules. And now if I can segue to some other points, I will. And if not,
maybe I'll let you. Go ahead.
Okay. So a couple, I think what we're really talking about is the thou shalt not lie rule and variations on that. We're not talking about conflicts of interest. I don't believe that every time lawyers get disqualified for a conflict, they should be disciplined. I don't think we're talking about competence. I don't think every time a lawyer is, does something negligent, they ought to be disciplined. We're kind of imperfect. There is a rule about competence, but I don't think it should be enforced to the hilt. We think integrity is really, really important. It's terrible for the profession and the public's perception of the profession if you have lawyers running around lying in public, on video, on tape, on the press, etc. And that's really what we're talking about. Now, I wonder, we talked about, does Texas have standing to challenge, the election results in Pennsylvania? I sometimes wonder whether we as a profession have standing to be on our high horse about professional integrity when we have a comment to the rules that say, but you can lie about what your client will accept as an offer. My client won't take a penny under 10,000. By defining that not as a lie, but as puffery, now it's okay. So I make the point because when you talk about the norms in political speech, are we talking about lawyer norms or political norms? So I think our norms have been completely degraded, not only by the conduct of people in the last however many years, but by the media. We no longer, and this is a point that Becky taught me, but we no longer have Walter Cronkite or others mediating what people can say, and anybody could put out their blogs and their tweets and talk on MSNBC or Fox News as commentators or whatever. And so when you talk about norms, if the question is, are they outside the norms? Was Rudy Giuliani outside the norms? Maybe he was outside the lawyer norms as we think of them having developed mostly in judicial process. Was he outside the norms of political speech? He was the norms of political speech. He and lots of people, some lawyers and many non-lawyers. And that's a problem. And so are we fighting a rear guard action now? Are we trying to hold the line and say, no matter what other people are doing in the Twitter sphere or on, social media, lawyers can't do that? I'd like to say that. I don't know why you have me as, the defender of liars. I do think there's interesting issues about federalism and separation of powers and, First Amendment and all kinds of other things, but don't misread me to think that I think lawyers ought to go out and lie on the stump. I don't think they ought to do that, but I also think that part of the solution is professional socialization, which I credit Dennis for, and that may be the best we can do as to some of this.
Bruce, on professional socialization and rules and norms, Yale historian Tim Snyder is a real hero of mine, the thought leader on totalitarianism. He tweeted with respect to my colleague's Giuliani complaint, lawyers should sign this. He cited his rule 5 of his 20 rules on tyranny. Professions to fight tyranny need to enforce their rules. He's not as fine a thinker on the rules as the people on this panel are, but that was inspiring to me. That a complaint that I had something to do with but was not the author of got that response from a hero of mine, meant a lot. And one last thing, another public service announcement. Anybody who hasn't signed our complaint can go to the Lawyers Defending American Democracy and sign, along with 7 ex-bar presidents and 25 judges.
Well, Dennis, I want to say a lot of people consider the lawyers who sign heroes, right? That people stand up and they have guts to do that, even if they think the discipline goes nowhere. So, we can look over time of lawyers throughout history who have stood up in very, very difficult circumstances.
And we can look in Germany at the lawyers who didn't stand up and who bought in and caused a lot of death.
But I don't mean to suggest, look, there are people on this Zoom who didn't sign. I don't mean to suggest that if you don't sign a discipline,
I agree.
You don't have guts. But, it really it does take lawyers like you to go forward. So we have 1 or 2 minutes left. Final comments. Ellen, you have a final comment, and then I'll end with Becky. Bruce, I consider what you said your final comment, if that's okay.
Yep.
Go ahead.
Yeah, and I mean, what I heard Bruce to be saying is, you know, as a profession, the stand that we should take, the hill that we should die on, is that integrity is the most important thing to our profession. Honesty and integrity is where we stand. And I mean, I also have to say that when I'm representing respondents, you know, when I read through the complaint, I'm like, oh, this is okay, this is okay. Oh, you lied. That's bad. That's bad, and the disciplinary system doesn't like it. So, you know, I think the disciplinary system is trying to hold that line, and we should hold that line. And while this has been, you know, some of these lawyers have been a disgrace to us, there have been many, many lawyers who stood up during these past 4 years and fought the good fight and made us so proud. And, you know, really, they were the resistance. And it made me very proud to be a lawyer.
Great.
So
Becky?
that's my final comment.
That's a great comment. Becky?
I don't really need to have a final comment. I mean, I'll say it has been a pleasure to be on this panel with all of you. And I hope somebody's copied the chat so I can read it later. And thank you so much, everybody. And thank you, Ellen, for inviting me to participate.
This has been terrific. I think this is one of my favorite panels. You know, we do, and I love sparring with Bruce, in case you all don't know that. I do that a lot. So thank you all. This has been wonderful. We will copy it. The recording is going to be available, as I said, on the Freedman Center website, probably on Monday, and it'll be on YouTube as well. Thank you all. And
I have a very short final comment, Bruce. As a trial lawyer, I never appeal to the sympathy of the jurors. Never. I would not do that.
Okay.
Thanks, Ellen. Thanks for having us.
Thank you, Alex. Wonderful. Thank you.